What we're seeing is real momentum with Métis rights. Basically, it started with the Pauley case, wherein the courts recognized a Métis right to hunt and trap. And this opened the door for basically litigation and the idea that, Métis, which have essentially been marginalized, if you will, amongst the Aboriginal populations historically, are now gaining traction. So we've now got momentum between the Pauley case, the Daniels case, and then most recently, in early March of 2013, we see that the courts have also recognized the right to land in Manitoba. So in the Manitoba Act, the Métis were promised certain parcels of land and a certain allotment of land for children, and this was never fulfilled. And the courts have now acknowledged that, in fact, the federal government failed to fulfill its promises under the Manitoba Act. So the question was whether or not Métis and non-status fell into the category of being Indians. The second and third components of the request made by the Métis were that there was a fiduciary obligation by the Crown, and thirdly, that there was a duty to consult by the Crown. Now, the Supreme Court did not rule on the second and third components of that request. However, they did rule on the first component and said, yes, indeed, looking at the case that Métis, off-reserve non-status Indians, do qualify and can be considered Indians under the Constitution Act, Section 91, subsection 24, 1867. And it decided to proceed without prejudice, meaning that the courts can reinterpret or revisit the other two requests. Now, this is following up, of course, on the success of CAP and Harry Daniels' plight to get the Métis included in the Constitution of 1982, where they're recognized by subsection 35 as a part of the Aboriginal people. So to be Aboriginal in Canada, you're either Inuit, Indian, or Métis. So the Métis, unlike treaties, which were signed by basically status and First Nation Indians, scrip is essentially the same concept as a promissory note by the government to Métis. And this area is being investigated and studied by scholars at the University of Alberta, Frank Tuff, Chris Anderson, who are looking at the implications of this. And I think that could be the next level, which would essentially provide a treaty-like relationship between the federal government and Métis. The reality and the challenge right now is the fulfillment and implementation of the claims that are existing. So where many self-government agreements are only this thick, the implementation documents can be this thick, because that's the real challenge. I mean, anyone can sit down and sign an agreement and say, sure, we'll do this and this for you, and you can do this for us. The reality is, how is that going to happen? How are we going to transform this relationship, and what does it look like? It's interesting because in the United States, we talk a lot about how the courts advance social norms and customs. So the courts are almost ahead of society. And I think that in many ways we're seeing maybe in Canada, the courts are ahead not only of society, but the federal government in terms of dealing with Métis issues in Canada. They're leading the way and opening up the doors, if you will, for Métis people to lay claim to that which is rightfully theirs.